Kenny MacAskill.
Thank you, Mr Deputy Speaker. The Lord Advocate and law officers, along with ministers, are part of Scotland's offices of state, enshrined in the Scotland Act 1998 that established the Scottish Parliament. It's why legislative change here is required. Thankfully, the post evolved and became a purely legal role, but an anachronism was built in. For the post holder is both principal legal advisor to the Scottish Government, yet also head of the prosecution service, or the Crown Office as it's known. Now that's something neither replicated elsewhere in the United Kingdom, nor indeed in any modern democracy. Conflict of interest precluding it. In England and Wales, an Attorney General advises government from within. Meanwhile, a head of prosecution service is both separate and independent from government. But not so in Scotland, and therein lies the problem.
I share my concern that even in the absence of any evidence of wrongdoing or malfeasance, any continued failure by the Scottish Government to address the separation of powers reinforces talk of deliberate and targeted harassment of individuals critical of the Scottish Government, its policies and its leadership.
Absolutely. Justice, there's a clear perception of there being far from equanimity or indeed even balance by the Crown. Now, James Wolfe has stepped down as Lord Advocate, replaced by Dorothy Bain. Miss Bain has an illustrious record of service and I wish her well. But the structural flaw remains. Personnel changes, no matter how merited, cannot resolve the fundamental flaw of a lack of separation of powers. The impartiality of the Crown's an imperative in a democracy. It must be seen to act in the public interest, not that of the government or its friends or allies. The coterie who surrounded Mr Wolfe and who were instrumental in driving these policies and actions, often against the wishes and views of long-serving staff, still remain. In particular, the Crown agent, Mr Hanvey, the senior civil servant. Unusually, amongst senior Crown staff, his career hasn't simply been as a Procurator Fiscal in Scotland, but has included service and secondment to British government departments. Maybe she could recuse herself from all direct government involvement. An in-house legal department exists. The duty to represent the government in court and pursue constitutional challenges remains, but that can be dealt with by external counsel. Change and a separation of powers there must be. The twin roles of the Lord Advocate in prosecution and in advising government are an historical anachronism, but entirely unsuited to a modern democracy. As a former Justice Secretary and someone who's appalled at what has happened, and I know that's echoed in legal circles, by all means.
Is he aware that the First Minister of Scotland has recognised that there's a case for reform here? And does he agree with me that all that's really needed is for this House to pass a bill to amend the Scotland Act to give the Scottish Parliament the power to make alterations to the role of Lord Advocate, and then the Scottish Parliament could properly consider what I think he's suggesting, separating it into roles akin to the Attorney General and the Director of Public Prosecutions in England.
But I do accept what the member says, that it should be for the Scottish Parliament to decide what the structure should be. It has to be a structure, I think, that will mirror most democracies south of the border or indeed elsewhere, but it should be for the Scottish Parliament. So I call upon the Minister to engage with the Scottish Government as a matter of urgency so that changes can be made to the 1998 Act. Changes providing for a complete separation of powers between the head of the prosecution service and the senior government legal advisor. Every modern democracy does so, and so must Scotland. The failures have been too many, and the risks are too great. For justice, Mr Deputy Speaker, has not only to be done, but must be seen to be done. Thank you.
Hear, hear.
Minister.
Thank you very much, Mr Deputy Speaker.
and I thank the Honourable Member for East Lothian and congratulate him for calling this adjournment debate. I know that he and others, and he in particular, have taken a keen interest in this subject, and I'm grateful for this opportunity to hear his views and those of others on this important constitutional issue, particularly in light of his former role as Cabinet Secretary for Justice in the Scottish Government. I recognise the concerns that the Honourable Member has made during his speech, namely that of the dual role of the Lord Advocate. And whilst the UK Government would have a role to play in any changes to the role of the Lord Advocate, I must stress that it would be inappropriate for me to speculate on what action should be taken at this time. I will therefore provide some context on the role of the Lord Advocate before I explain the set process any changes must go through before the UK Government can take a position. I'll give way.
For giving way, I hear that he's not going to speculate or set out a plan, but does he agree with me that one route might be for this Parliament to pass a bill amending the Scotland Act so that the dual role of the Lord Advocate could be revisited by the Scottish Parliament? Because, of course, under the current Scotland Act, the role of the Lord Advocate is reserved to this Parliament. So does he agree with me that one potential way forward would be to pass a very straightforward bill that gave the power to change the role to the Scottish Parliament?
I thank the Honourable and Learned Lady for her intervention, and although that is possible in theory, what I will explain later is why in practice the UK Government would choose not to go directly down that route. The context of the role of the Lord Advocate is the Scotland Act 1998, which I'll refer to for brevity as the 1998 Act. Section 48 of that Act makes provision about the appointment of the Lord Advocate and their removal from office, which remain the prerogative of the UK Parliament through Schedule 5 of the Act. There are too many of those to list, but a few examples would be foreign affairs, international trade, defence, national security, energy, and of course the Constitution. Since 1998, there have been two major adjustments to the devolution settlement, the Scotland Acts of 2012 and 2016. On the role of the Lord Advocate, which is reflected in the 1998 Act, as the Honourable Member will be aware, the Lord Advocate is the Scottish Government's most senior law officer and principal legal advisor, which is the topic of this debate. Section 48 of the 1998 Act, in addition to providing for the appointment of Lord Advocate and their removal from office, also makes provision about the independence of the Lord Advocate in her capacity as the head of the systems of criminal prosecution and investigation of deaths in Scotland. This is to ensure the traditional independence of the Lord Advocate in taking decisions related to those matters continued after they became a member of the Scottish Government. The Lord Advocate's role as head of the systems of criminal prosecution and investigation of deaths is protected in Section 29 of the 1998 Act from modification by an Act of the Scottish Parliament. In terms of amending the Lord Advocate's role, the Honourable Member has referred to amending the role given the limitation on legislative competence in Section 29 of the 1998 Act. Any formal separation of the responsibilities would require legislation. And whilst the UK Government has the power to bring forward legislation to make this change, in practice we would want to ensure the Scottish Government have first put their proposals to the Scottish Parliament for scrutiny. It's only right that the Scottish Parliament has an opportunity to scrutinise and debate these proposals. Only once these proposals were agreed in principle in the Scottish Parliament would we expect the Scottish Government to make a formal representation to the Secretary of State for Scotland as custodian of the devolution settlement, and then the UK Government would consider the next steps.
On that point, there's surely nothing to prevent the Scottish Government from returning to the informal arrangement of the Salmond Government, where the law officer did recuse themselves from cabinet discussions in an informal basis, despite the separation of powers not being in place, and that would at least show some willing towards a formal separation or consideration of that matter before the Scottish Parliament.
Well, I thank the Honourable Gentleman for his intervention, and of course what he's referring to is an informal arrangement, so by definition there would be nothing to stop that informal arrangement if that was agreed by those involved. But that's not, again, it's not for me as a UK Government Minister to decide upon that. In conclusion, Mr Deputy Speaker, the UK Government continues to work closely with the Scottish Government on all amendments to the 1998 Act. Devolution, brought about by the 1998 Act, is the means by which our two governments work together. The 1998 Act is also the means by which we continue to live in one of the most long-lasting political unions in history as part of a devolution settlement. Thank you.
The question is that this House do now adjourn. As many as of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. Order. Order.